If the integrity of the criminal legal system depends on the truthfulness of its officers, then its legitimacy hinges on its ability to identify, correct, and prevent dishonesty. The chapters preceding this one have explored the legal mandates, ethical obligations, and systemic failures surrounding the duty of candor. We've seen how officers who lie through omission, fabrication, or silence can derail cases, erode public trust, and produce devastating outcomes. But the story cannot end there. Recognition without response is complicity. That is why Part 5 turns to the imperative of reform and accountability. This section focuses on solutions real, implementable changes that can shift the culture and structure of law enforcement toward one that values and protects complete candor. It explores mechanisms of transparency, oversight, technological innovation, and structural reform designed not merely to punish dishonesty, but to prevent it. The goals of reform are threefold: to create systems that identify misconduct and dishonesty early, to ensure consequences that are fair, proportionate, and effective, to establish a new institutional culture in which truthfulness is non-negotiable. The reform conversation is not new, nor is it easy. It must confront powerful resistance-entrenched interests, political sensitivities, and bureaucratic inertia. It must navigate competing values: officer privacy versus public trust, due process versus expedient action, loyalty versus accountability. But reform is not a luxury, it is a necessity. Without it, the obligation of candor remains aspirational rather than actionable. The case for structural reform. At the heart of any reform conversation is a stark reality. The current systems of police discipline, oversight, and disclosure have repeatedly failed to prevent dishonest officers from remaining in positions of power and influence. Officers with documented histories of lying under oath, falsifying reports, or engaging in misconduct have continued to testify in court, build criminal cases, and influence life-altering outcomes. These failures are not theoretical, they are documented, repeated, and often litigated. Structural reform is essential because the issue is not merely one of individual conduct, it is one of system design. We need to rethink how law enforcement agencies are organized, how oversight bodies are empowered, how data is collected and shared, and how misconduct is tracked across jurisdictions. Most importantly, we must shift the center of gravity from protecting the institution to protecting the public's right to truth. This section begins with two chapters that offer blueprints for this transformation, one focused on institutional transparency and accountability, and the other on technological and procedural innovations. Transparency as a foundation. Transparency is not just a buzzword, it is the cornerstone of legitimacy. In the context of law enforcement, transparency means that the public, the press, defense attorneys, and courts have access to information about officer conduct, disciplinary history, and the integrity of investigations. It means that the state does not hide behind confidentiality or delay when the stakes are justice itself. One of the primary reforms being pursued across jurisdictions is the public release of police disciplinary records, particularly those related to dishonesty or misconduct. In many states, such records remain hidden from public view under civil service protections, union contracts, or outdated privacy laws. Reformers argue in courts increasingly agree that the public has a compelling interest in knowing whether the officers testifying in their courts or patrolling their communities can be trusted. Another key element of transparency is the publication of Brady/Giglio lists, or at least the establishment of standardized criteria and reporting procedures. When defense attorneys must guess whether a key witness has a history of dishonesty or discover it by accident through litigation, the system is already compromised. Making these lists accessible, or at the very least discoverable under court order, is a basic constitutional safeguard. Beyond records and lists, transparency also means truthful communication during investigations, use of force incidents, and public controversies. Agencies must stop spinning narratives before the facts are known. They must release body camera footage promptly, correct false statements quickly, and own up to mistakes publicly. These practices are not acts of weakness. They are demonstrations of institutional maturity and ethical leadership. Real accountability requires consequences. Accountability means more than internal reviews and strongly worded memos. It means meaningful consequences for violations of the duty of candor. This includes decertification of officers found to have committed perjury or falsified evidence, termination or reassignment of officers who are no longer fit to testify in court, prosecutorial exclusion of witnesses with known credibility issues, judicial findings that formally recognize false testimony and flag it for future proceedings, civil penalties for agencies that fail to disclose known misconduct. Accountability must also extend to supervisors, prosecutors, and police chiefs who fail to act on known issues. Systemic failure is never the result of one dishonest actor. It requires a chain of negligence, silence, or complicity. For accountability to be real, it must be consistent. Officers should not escape scrutiny because of political connections, departmental favoritism, or jurisdictional transfers. National certification and decertification systems, such as those now proposed by organizations like the International Association of Directors of Law Enforcement Standards and Training, IADLIST, offer a path toward more consistent professional consequences. Cultural reform, changing the incentives. Beyond legal structures, real reform requires a transformation in the culture of law enforcement. For too long, officers who get the job done, even through unethical means, have been rewarded with promotions, accolades, and public praise. Officers who speak up about misconduct are more likely to face retaliation than recognition. This must change. Departments need to adopt a culture that rewards honesty, self-reporting, and accountability. This can include formal recognition and promotions for officers who demonstrate integrity under pressure, whistleblower protections for those who report misconduct, regular ethics training that is interactive and scenario-based, not box-checking, supervisory reviews that emphasize quality of work, not just clearance rates or arrest numbers. Culture change must begin at the top. Police chiefs, sheriffs, and command staff must set the tone. They must model candor, punish dishonesty, and embed ethical standards into every level of the organization. Reform is contagious, but so is misconduct. The leadership decides which spreads. Community-led and independent oversight. Reform without independent oversight is self-regulation by the accused. Communities must have a seat at the table and a meaningful voice in deciding how their police departments operate. This means investing in civilian review boards with real authority to investigate complaints, issue findings, and recommend discipline. It means giving inspector generals or ombudspersons full access to records and unrestricted authority to publish reports. It means ensuring that community members have access to complaint data, use of force statistics, and officer misconduct summaries. Community engagement also requires outreach and trust building. Law enforcement agencies must recognize that communities, especially marginalized ones, are not merely subjects of enforcement. They are co-creators of public safety. Agencies that shut out community input are building policies in a vacuum and reinforcing mistrust. Legislative action and national models. While many reforms can and should happen at the local level, some changes require legislative action at the state or federal level. These include state laws mandating Brady/Giglio reporting by law enforcement agencies, open records laws that remove confidentiality shields from misconduct findings, funding incentives for departments that comply with transparency and training requirements, federal support for national officer decertification databases, model policies distributed by federal or state commissions to encourage uniform standards. Examples of successful legislative reform include California's SB 1421, which opened certain categories of police disciplinary records to public inspection, and New York's repeal of Section 50A, which had shielded officer records from disclosure for decades. These laws have been used by journalists, watchdogs, and attorneys to uncover misconduct and push for further reforms. Federal action is more limited, given the decentralization of policing in the United States, but still critical. The Department of Justice can set standards, attach conditions to grants, and conduct pattern and practice investigations of noncompliant agencies. Congress can fund data transparency efforts and require public reporting as a condition of funding. Conclusion: the path to reform is neither short nor simple, but it is necessary and it is already underway. From courtrooms to city councils, from state legislatures to community coalitions, the call for truth in law enforcement is growing louder. The public is demanding more than apologies. It wants guarantees of transparency, accountability, and meaningful change. The obligation of complete candor is not theoretical. It is a constitutional right, a democratic necessity, a moral imperative, and it is the duty of every public servant to uphold it not selectively, not quietly, not when convenient, but always. Part 5 of this book is dedicated to the work of building that world. A world in which no one is convicted based on a lie. A world in which law enforcement's credibility is not assumed but earned. A world in which truth is not the exception, but the rule. I am a dedicated author and researcher specializing in the intricate nexus of technology, law, and government. My extensive body of work includes a diverse array of books, scholarly articles, and policy papers that delve into the evolving challenges and opportunities presented by technological advancements within legal and governmental contexts. Through rigorous analysis and insightful exploration, I examine how emerging technologies such as artificial intelligence, cybersecurity, data privacy, and blockchain shape and are shaped by legislative frameworks, regulatory practices, and public policy initiatives. My publications aim to bridge the gap between technical innovation and legal governance, providing comprehensive resources for policymakers, legal professionals, technologists, and academics alike. By addressing critical issues like digital rights, cyber law, technology-driven governance, and the ethical implications of technological integration, my work contributes to the development of informed and adaptive legal systems capable of responding to rapid technological change. I am committed to fostering a deeper understanding of how technology influences governmental operations and legal standards, and vice versa, thereby promoting the creation of robust, equitable, and forward-thinking policies. In addition to my writing, I actively engage with government agencies, legal institutions, and technology firms to offer expertise and collaborate on initiatives that ensure the responsible and effective implementation of technology in public spheres. My dedication to exploring and elucidating the intersections of technology, law, and government underscores my commitment to advancing knowledge and facilitating informed decision-making in an increasingly digitalized world.